Recipe of success. Study while others are sleeping. Work while others are laughing. Prepare while others are playing and dream while others are wishing. Hello guys, welcome back with another video at the Legal Entertainment channel. Today we are gonna discuss about the laws or provisions as to the bail and bonds. As you know guys, chapter 33 of CRPC deals with bail's provision, which is from section 436 to 450. So let's proceed with the provisions of bail. Guys, what is bail? Released of an accused on furnishing a personal bond or surety to abide by the conditions imposed by the court and stand his trial before the court. Now, objective of the bail, it is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it can be required to ensure that an accused person will stand his trial when called upon. Personal liberty is very precious fundamental right and it should be curtailed only when it becomes imperative according to the peculiar facts and circumstances of the case. Now, can a person accused of non-bailable offense apply for pre-arrest bail? Here, pre-arrest bail means anticipatory bail. Okay guys? किसी व्यक्ति ने अगर नॉन बेलेबल ऑफेंस कमिट किया है तो क्या वो एंटीसिपेटरी बेल के लिए अप्लाई कर सकता है? यस, a person accused of non-bailable offense can apply for pre-arrest bail or an anticipatory bail. Section 438 of CRPC 1973 grants the power to an accused person to apply for an anticipatory bail before the session court or high court. Anticipatory bail session court और high court में आप लगा सकते हैं. The Honorable Supreme Court for the first time clarified the laws relating to the anticipatory bail in the case law of गुरबख्श सिंह सिबिया etc. वर्सेस स्टेट ऑफ पंजाब 9 अप्रैल 1980. गुरबख्श सिंह सिबिया वर्सेस स्टेट ऑफ पंजाब ने सुप्रीम कोर्ट ने पहली बार 1980 में एंटीसिपेटरी बेल के रिगार्डिंग क्लैरिफिकेशन दी थी. नाउ इस केस लॉ में सुप्रीम कोर्ट के द्वारा क्या कहा गया था ये हम बात करते हैं. फर्स्ट पॉइंट जो है, द पावर प्रोवाइडेड अंडर सेक्शन 438 दो ऑफ extraordinary character does not justify its use in exceptional cases. Due care, caution, and circumstances must be taken while exercising such power. Second point is, the applicant applying for anticipatory bail must satisfy that he has the reason to believe that he may be arrested for non-bailable offense. जो एप्लीकेंट एंटीसिपेटरी बेल के लिए अप्लाई कर रहा है उसको कोर्ट को सेटिस्फाई करना होगा, रीजन टू बिलीव, विश्वास दिलाना होगा कोर्ट को कि वह व्यक्ति नॉन बेलेबल ऑफेंस के लिए अरेस्ट हो सकता है. नाउ थर्ड पॉइंट इज, फाइलिंग of the FIR is not a condition precedent to the exercise of the power under section 438. The imminence of likely arrest found on a reasonable belief can be shown to exist even if an FIR is not yet filed. However, anticipatory can be filed even after the FIR as long as the applicant has not been arrested. Condition क्या है anticipatory bail लगाने की? FIR फाइल होने के बाद में भी एंटीसिपेटरी बेल लगाई जा सकती है एज लॉन्ग एज द एप्लीकेंट हैज नॉट बीन अरेस्टेड. लेकिन जो एप्लीकेंट है वो अरेस्ट नहीं हुआ होना चाहिए. नाउ फोर्थ पॉइंट इज, blanket order like whenever arrested for whichever offense whatsoever of anticipatory bail should not be generally be passed. ब्लैंकेट ऑर्डर का मतलब है आप ये नहीं हो सकता कि आप कभी भी जाकर एंटीसिपेटरी बेल के लिए लगाओ कि हाँ अगर फ्यूचर में मैं कभी भी अगर अरेस्ट होता हूँ तो ये मेरी एंटीसिपेटरी बेल काम आएगी. ठीक है, तो ब्लैंकेट ऑर्डर पास नहीं किया जा सकता एंटीसिपेटरी बेल में. Fifth point is, the operation of an order passed under section 438 clause 1 need not necessarily be limited to the point of time. However, the court may, if there are reasons for doing so, limit the operation of the order to a short period until the filing of an FIR in respect of the matter covered by the order. Sixth point is the courts can impose reasonable condition while granting anticipatory bail in order to keep a balance between the personal individual right and investigational power of the police society's interest. Now, the court can take sufficient surety to their satisfaction to ensure that the accused will not violate the condition imposed or will not be available to stand his trial. Eighth point is the court's task while deciding an application for anticipatory bail must be to balance personal liberty of an accused and investigational powers of the police. Now, कई बार हमारे दिमाग में आता है कि क्या एंटीसिपेटरी बेल अनलिमिटेड पीरियड के लिए भी ग्रांट की जा सकती है? Can anticipatory bail be granted for an unlimited period? So, in Shushila Agarwal versus State and City of Delhi, 29 January 2020, in this case law, 10 conditions were discussed by the Supreme Court that whether anticipatory bail can be granted for an unlimited period. So here is the answer, guys. The life all duration of an anticipatory bail order does not end normally at the time and stage when the accused is summoned by the court or when charges are framed, but continues till the end of the trial. Anticipatory bail will continue till the end of the trial. Again, if there are any special or peculiar features necessitating the court to limit the tenure of anticipatory bail, it's valid for a court to do so. Now, what are the factors for granting an anticipatory bail? First of all, court will say the nature and gravity of the allegation. Second point is genuineness of accusation made against the accused. Third one is prima facie or reasonable ground to believe that the accused had committed an offense. Next one is chances of the accused absconding from the process of the law or whether the accused has roots in the society. Next, antecedents of the accused, that is whether he is a habitual offender or not. Next one is chances of the accused creating hurdles in the fair investigation or the trial. Next factor is chances of complainant witnesses being threatened or evidence being tampered. Next one is case requires custodial interrogation. Next factor for granting an anticipatory bail, another fact about likelihood of the offense being repeated. And the last one, analyzing objectively whether the accused had joined or cooperated with the investigation. Now guys, you have seen or heard many times that accused is not cooperating in the investigation or accused is not about to cooperate with the investigation agency. So what is cooperation? What is the meaning of cooperation in investigation? So here are some case law regarding that. संतोष versus State of Maharashtra 2017 का ये केस लो है. इसमें कहा गया था merely because accused does not confess as the police wants him to, or it cannot be said that he is not cooperating with the investigation agency. अगर कोई accused पुलिस के सामने जो पुलिस उससे कन्फेस करवाना चाहती है वो कन्फेस नहीं कर रहा है तो पुलिस ये नहीं कह सकती कि that accused is not cooperating with the investigation agency. Here you can refer Section 161 of Cr.P.C, that is examination of witnesses by police. Now, next case law is Samrat Singh Nirula and others versus State of NCT Delhi 2015 SCC. It is the settled law that the court can draw an adverse inference against the accused, but the police cannot compel him to answer by custodial interrogation. No doubt that police have power to investigate the matter as per their way in accordance with the law, but it does not mean that the police will exercise power just to because there are allegations against the accused in the complaint filed by the complainant. So, guys, these are some case law regarding the bail provision. There are some more case laws regarding the bail provisions we will discuss in the next part. So guys, till that period, thank you so much. We'll meet in the next video.